Hello, Dr. Tamara. We would like to invite you to learn something new with us.
Hello, Miss. I'm Joyce Lee Sing.
Hi, Dr. Tamara. My name is Jie. I hope you can sit back and enjoy our presentation.
Hi Miss, my name is Lim Wei Jie, and you can call me Ivan.
Hi, Dr. Tamara. I am Zun Yang. I hope that you are doing well during the MCO period.
Hi, my name is Celeste Chua. Today, I'm going to talk about the introduction of administrative law. Administrative law is the law to regulate the relationship between the state and the citizen, which seeks to provide accountability and responsibility in administrative functioning. The principles of the administrative law system are found in the ideas of democracy and the rule of law. The theoretical basis of judicial review of administrative decisions comes from the doctrine of ultra vires to examine administrative decisions to ensure that they are within the scope of the power under which they were made. Under administrative law, a public body must act in a way that is lawful, reasonable, procedurally proper, and human rights compliant. Human rights compliance was made a key component of administrative law when Section 6, Subsection 1 of the Human Rights Act 1998 was enacted, which brought certain articles of the European Convention on Human Rights 1950 into the law of England and Wales. So in this assignment, we are going to discuss the theories of administrative law and the application of the most relevant theory to the worldwide events in 2020.
Thank you Celeste, and now I'll be presenting the point of red light theory. As stated above, there exist quite a few theories on how administrative law functions as a body. This paragraph will be further discussing on the red light interpretation of judicial review, which is the contradicting interpretation of the green light theory. The 19th century Dacian constitutional analysis is where the red light theories are rooted in. Their view of administrative law is by controlling the state activities, the courts are able to ensure the protection of individuals. Planned economies or welfare states have applied this tin rule, which is what is now known as the red light theory of administrative law. The theory tends to emphasize on citizens' rights and the law as a brake on state action. The courts achieve this by ruling different rules and regulations. As Adam Tompkins identifies, red light theories with the following four notions. The first one being that law is autonomous to and superior to politics. In addition, the administrative state is perceived as something which needs to be kept in check by law, in his view. Among the reasons that individuals should not purely depend on centralized processes of decision-making is due to the complexity and pervasiveness of administrative decisions. Decentralized decision-making seems to be the more favored processes as a result of increased transparency and accountability. If structured in a more accessible and less costly way, the courts can exercise judicial control and ensure control and publicity in all these procedures. Furthermore, Tompkins also states that through rule-based adjudication in courts is the preferred way of exercising judicial review by all the red light theories. What he means by this is that red light theories prefer the interventionism of judicial review, which is maximized in the name of checking of arbitrary power and promotion of the rule of law. Also, Tompkins perceives that the goal of red light theories should be to enhance individual liberty, where liberty is conceived as being the right to be left alone. The absence of external constraints, where an idea of liberty best realized by having a small government. As Tompkins' fourth point reveals, this theory rests on a distinct normative perspective, one where, according to Howler and Rawlings, the main function of law being as to keep in check on any abuse of state power and subject it to judicial control, resting it on a preference for a minimalist state. An example of a judicial review that is unapologetically red light would be Hong Kong, due to the power dynamic that exists in Hong Kong as an institution between the judiciary and the mainland government. A very clear demarcation of power as between the courts are found in the Basic Law, to whom power is only delegated by the National People's Congress, and the NPC Standing Committee, which under the Basic Law itself has ultimate and full power to interpret all provisions of the law. Furthermore, by adopting this theory, Lord Diplock in Council of Civil Service against Minister for the Civil Service stated the requirements for judicial review, which were emerged earlier in the Wednesbury unreasonable test. Hence, irrationality, illegality, and procedural impropriety could be regarded as the grounds of judicial review. In the present day, the red light theory is looked in a broader sense. Due to the increasing privatization of government bodies, the judicial review has extended to the private sector as well. The landmark decision on this regard is R against panel on takeovers and mergers, which upholds that the decisions of a private body which reflects public functions affecting individual rights may be amendable through judicial review. That's all for my part, and now Jun Yang will be presenting the next point.
I'd like to say thank you to my groupmate Ivan for such a wonderful presentation about the red light theory. And now I'm going to talk about the green light theory, which has a contrary view with the red light theory. The green light theory is an administrative law that exists to help the state to meet certain policy objectives. It tends to minimize the role of the court and underplay the existence of the general principle. The green light theory expounds the idea of control and accountability through the democratic political process rather than through investing the judge in this role. The green light theory advocates the use of the law to promote the efficient rulemaking and are committed to a model of government approach toward the administrative process. The administrative law is to facilitate the operation of the states, enhance the efficiency, and simplifying the procedure. The law is considered as a facilitative tool rather than a controlling mechanism so that it can act as a weapon in the administrative bodies. As mentioned by Adam Tomkin in the journal article, which is in defense of the political constitution, the green light theory has 4 different views, which is the law, states, notion of control, and liberty. The green light theories believe that the law is nothing more than a sophisticated political discourse and is neither autonomous from politics nor superior to administration. The green light theories also believe that the public administration is not a necessary area to be tolerated but a positive attribute to be welcomed. They also trust that the objective of the administrative law was not to stop the bad administrative practice, but to encourage the good administrative practice, which is to control the administration by channeling and guiding, and the rule-based adjudication might not be the necessarily best way to do this. The ultimate goal of the theory was to enhance the individual and collective liberty. When a matter complained of involves the issue of high policy, the court will refuse to exercise the supervisory function over such decision. The matters of public policy are to be determined by the executive but not the judiciary, and any purported attempt to control the decision will be regarded as the violation of separation of powers. There are several instances that the judge showed massive deference and non-justiciability towards the executive favoring the green light theory. In the case of R versus Secretary of Foreign and Commonwealth Affairs, it has been affirmed that the judge cannot interfere with the exercise of discretionary power if they would need to decide a non-justiciable issue in order to apply for the ground of review. The case of R versus Environment Secretary would also take the similar position that the Wednesbury unreasonable test was unsuitable to apply due to the context. Although the state acts in the welfare of the people, it is discretionary to provide the facility in which the court cannot interfere. In a nutshell, the green light theory are more focused on the question of law which is specifically to the public administration.
It should be noted, however, that a decision maker may take a red light approach in some instances and a green light approach in others. In many instances, it will be a combination of the two, as can be seen in the cases of Harden against Vandenberg Foods and Midland Bank against Marden. In these cases, the Court of Appeal and the House of Lords are in search for a golden mean between red light and green light approaches to a judicial review-like jurisdiction.
The world is not entirely red or green. There's a third approach exists which is known as the amber light theory, or we can call it as liberal normativism. The amber light theory is the general theory of liberal legalism that may be applied to the specific context of the administrative law. The amber light theory intends to focus on the issue of judicial remedies and elaborates the constitutional role of judiciary beyond that advocated by the red light theory. The amber light theory has a different view with the green light theory on the issue of accountability, whereas the green light theory sees the political institution as adequate to control the state power, while the amber light theory intends to develop the administrative law procedure and principle to supplement the democratic politics control over those who exercise the state power. The amber light theory can be seen as a mixture of the green light theory and red light theory upon two principles. The first principle is that it is necessary to have judicial as well as political control over those administrative process. The second principle is that the judicial review should be balanced against the systemic needs of the efficiency. Although the green light theory is used to uphold the separation of powers, the court could interfere on a matter that the decision made was so unreasonable to avoid the abuse of power by the government. Okay, that's all for my presentation today. I believe that after our presentation, you are now more familiar with the red light theory, green light theory, and even the third approach, which is the amber light theory. And now, I would like to pass it on to my groupmate, Joyce, to elaborate more about the right-based approach. Thank you.
In an important series of articles written by Sir John Laws, Lord Justice of Appeal, he presented an essentially rights-based approach to ensure the protection of fundamental rights through the application of judicial review. This will require public bodies to implement rights-based justice and act in a restrained manner that honors the rights-based limitation on its powers. A decision made by public authority is deemed to be unlawful if it amounts to unjustifiable violation of one's rights, which are fundamental precise. Being a public authority implies acceptance of the duty to respect and uphold the fundamental rights of its addressees. In cases of judicial review, the greater the encroachment on one's fundamental rights demonstrated by a public body, the greater the justification must be propounded. A right, therefore, is a metaphorical trump card held by an individual to prevent the government or society from doing a certain thing, even if doing that thing would be in society's general interest. In the United Kingdom, a theory of higher order law has emerged, as Sir John Laws persists that there is an imperative need to call a higher order law into existence in which human rights and constitutional fundamentals can be protected by courts. The law relating to rights can be said to constitute a higher order of law which could not be abrogated as other laws can. All exercise of public authority should not overstep these limits and should be compliant with it. This theory has been echoed by other commentators like Paul Craig, Geoffrey Joel, and Don Oliver. Hence, rights will be protected by the unelected and unrepresentative courts. According to an essential conception of rule of law, the protection of fundamental rights is an important aspect of government. Such rights reflect an underlying idea of human equality and dignity. It is part of a substantive rule of law framework that affects statutory interpretation and resists legislative departures unless Parliament expressly legislates against them. This approach is postulated on a particular conception of liberalism and individual autonomy. The rule of law is encircled by the concept of freedom, certainty, and fairness, which cannot be repudiated by courts. The fundamental principle is that no one can be punished unless there is a clear breach of law. Therefore, rights can only be restrained by legal authority and not by executive fiat. Responsibility for enforcing this higher law against countervailing governmental action is assigned to the courts, as courts with judicial power are the final arbiters in interpreting and applying the law, ensuring that the framework of fundamental principles of the Constitution will be upheld. Thomas Poole has pointed out that the theory replaces the role of the court in the hierarchy of government rather than its traditional role as the enforcer of Parliament's will. In the context of the United Kingdom's constitution, this had led to a crucial issue regarding the tension between the idea of fundamental rights and the doctrine of parliamentary sovereignty. By virtue of the doctrine of parliamentary supremacy, it must be capable of limiting or even abrogating rights, regardless of how fundamental they might be. The question of whether rights can be regarded as fundamental within a legal system comply with the concept of legislative supremacy has arose. In the interpretative process, courts must differentiate some common law rights, convention or fundamental statutes from ordinary law as they have a higher constitutional status and try to reconcile it with sovereignty of Parliament to prevent conflicts. The important case applying fundamental common law rights is the case of R. and Secretary of State for the Home Department ex parte Sims. It was held that a government policy pursuant to the Prison Rules 1964 denying prisoners access to the journalists for interviewing purpose was unlawful. According to Lord Stein, these provisions would undermine the fundamental rights to freedom of expression as guaranteed in Article 10 of the European Convention. Further, it was stated by Lord Hoffman that Parliament can, if it chooses, legislate contrary to fundamental principle of human rights. However, it is ultimately political but not legal. Moreover, fundamental rights cannot be overridden by general or ambiguous words. In this case, courts are more willing to develop common law doctrines in a manner with the European concept of necessity and proportionality. As mentioned above, the fundamental individual rights are vindicated by higher order of law. Parliaments and courts are subject to rule of law and cannot take any action which amounts to its repudiation. Eventually, there are limits on parliamentary sovereignty as the courts are allowed, even demand to give effect to Parliament's legislative power within the context of rule of law. This shows the court's inviolable responsibility to identify and uphold the rule of law. It can be said that citizens' right is protected by ordinary law against unlawful action of public authority, including right to life by receiving proper treatment. Nonetheless, in the case of R and Cambridge Health Authority ex parte B, where a child has been denied treatment due to shortage of resources, John Lawes contended that the child's right to life under the European Convention on Human Rights is violated and required the health authority to justify the interfering with this right. However, the Court of Appeal found that the health authority had acted lawfully in its refusal by taking its budget into account. It was held that, in certain circumstances, difficult judgments have to be made as to how a limited resource is best allocated to the maximum advantage of the maximum number of patients.
As mentioned above, the government should play a leading role in resolving issues on the scope and substance of individual rights with the help of the court that scrutinize governmental actions. Hence, the red light theory and the right-based approach will be used most of the time to ensure fundamental rights of the citizens are protected. However, by referring to the past, it would be justified that the green light theory is more likely to be used during a crisis among all the other approaches. If the government were to favor the use of red light theory and right-based approach during the crisis of COVID-19, it may worsen the situation as there would be more claims brought up by the citizens to protect their fundamental rights. This will substantially reduce the effectiveness of governmental actions, leading the country to a dead corner. This can be said so because the green light theory is based on trust in the executive and its internal mechanism for ensuring good governance and accountability, compared to the red light theory, which states that the function of the law is to control the government's action and focuses on protection of rights and liberty of the citizens. Current pandemic of COVID-19 can be regarded as a crisis, as the Member of Parliament Matt Hancock commented that coronavirus pandemic is the most serious public health emergency that our nation has faced for a generation, and it may be significant to depart from the way we do things in peacetime. Therefore, the green light theory is being used as it gives more power to the government to take measures as they think is necessary in handling the current situation. An example of power that the government has is passing the emergency bills like the Coronavirus Act 2020. This would enable the government actions to be less subjected to review by the court in order to ensure effectiveness in the process of making policies. As stated by Martin Ketterfurter, defeating the COVID-19 crisis could need a wartime coalition government which enables the government to have more power in running the country. During the wartime, the government had sweeping authority to govern through the regulations with no parliamentary sanction under the Emergency Powers Act 1939. Hence, compared to the green light theory used during the time, the emergency bill by Matt Hancock is not as similar. It only allows police and immigration officials to detain persons suspected of carrying the coronavirus. Even if such actions are allowed by the law, but still can be said to be unconstitutional as it may be in violation of the authority and rights defined and granted in the government's constitution. This had also opposed the right-based approach. Due to this, issue arose where citizens' fundamental human rights were breached by the actions of government under the green light theory. An example can be seen in the US, where citizens protested on the issue of infringement on their rights laid down in the Constitution, as the federal and state governments have had to shutter large swaths of the economy to slow the spread of the virus. As mentioned, the red light theory is to control the government's function so that it protects the individual's rights. It should be looked at together with the right-based approach, which states that those rights were not only limited to the right to liberty of an individual, but also right to a healthy life of the others. Whether the government action of restraining movement constitutes a breach of right to freedom or a protection to right to life is needed to be closely examined. These governmental actions are said to be proper and necessary as COVID-19 is said to be a crisis and green light approach is used while mixing with a limited extent of right-based approach that protects human rights. It is noted that even if the government action of implementing regulation, they may constrain one's freedom, but this must also be balanced with the necessary protection of the right to a healthy life. It was stated by some scholars that the principal duty of the government in this crisis is the protection of life. Any restrictive social measure or interference with individual rights need to be lawful, proportionate, and necessary to maintain public health. The case of R against Health Authority ex parte B, as mentioned by Joyce above, had clearly shown that the right of an individual should be balanced with the protection of fundamental rights of the public. In this case, the court was in the view that protection of public benefit should be prioritized over one's fundamental right. Hence, it is justified that in the current situation, the government would act in a way to protect the public's right to a healthy life rather than favoring the individual's right to liberty. The issue of balancing different rights of a citizen can be seen in the case of BP against Surrey County Council. In this case, the plaintiff is an elderly with incapacity who had been placed in a care home by the local authority. Despite that, he was still engaged with his family. But due to the outbreak of COVID-19, his family members were not allowed to visit him. With comprehensive consideration, it was decided that despite having the right to respect for private and family life, the patient's right to a healthy life should be the main concern, and remaining in the matrimonial home without being visited by his family member is said to be a decision in his best interest.
In Malaysia, One of the ministers said the implementation of the movement control order currently was an individual's right to enjoy a healthy life. Thus, the government cannot be said to have ignored human rights because it was allowed by Prevention and Control of Infectious Disease Act 1988 and the Police Act 1967. On the other hand, the government may also take into account other approaches, as mentioned above, so as to assist the application of green light theory. Acting in this way may win public confidence and cooperation, but it may be confirmed that green light theory would still be the main approach to drive the government in the current crisis. It is said that even if protecting the human rights are important, but it must also give way to collective right to healthy life, because the right to liberty of an individual can be said to be at the bottom of the hierarchy in this current situation, and the right of healthy life of the public is the most important thing that is needed to be safeguarded by the government. Currently, the situation of COVID-19 is being under control, and hence it can be seen that the government had eased the restraint movement order as the virus is not as serious compared to the earlier period. This action of government of relaxing the movement control order is more proportionate by waiving the importance to protect individuals' right to freedom with the public importance. All in all, even if the green light theory being used by the government during the crisis may allow the government to be less subjected to court jurisdiction, but the individuals still reserve the right to review the decisions made by the government so as to protect their own fundamental rights. This is because the judiciary will be able to interfere with the state activities so long that such interference is justiciable, no matter which theory has been used. As discussed above, the administrative law mechanism is a vital element in the constitutional framework by safeguarding the democratic ideas of accountability and transparent, participatory and rational government, and different theories were implemented to interplay between law and politics, the individual and the state, political and law. Although the green light approach seems to be the most relevant approach towards the pandemic nowadays, solutions should be found in a more flexibility way to support a more successful outcome, to maintain the consistency, predictability, legitimate expectation of the people, and the growth of the country.
That's the end of our presentation. How was the experience with us? Don't forget to give us a thumbs up and please call
1311 111111
for any feedback. We hope to see you soon. Thank you and take care.